Hello, Indiana. It's good to see you all. I am Hank Chambers. I'm a law professor here at the University of Richmond, and I want to welcome you to day three, the top 12 competition. You all have done a fantastic job getting here. We will introduce our fellow judges, and then we will hear from you all, and then we will read the question. So my fellow judges, David, if you want to start.
My name is David Hudson. I'm a professor at Belmont University College of Law in Nashville, Tennessee.
Hi, good morning. My name is Ben Glickman. I'm an attorney with the California Attorney General's Office. I'm also an alumnus of this program. I was at the national competition back in 1995. And I look forward to our conversation. If we manage to stump you, just hold real still and we'll think Zoom froze.
Now, please, students, tell us who you are and introduce us to your teacher.
Good morning, judges. We are Unit 5 from Team Indiana, hailing from Hamilton Southeastern High School in Fishers, Indiana. All four of us are seniors this year. Next fall, I'll be studying political science at Wabash College, and my name is Jake Weber.
Hello, judges. I am Carter Nelson. Next year, I will attend Purdue University to study supply chain information and analytics.
Good morning, judges. My name is Donia Zandi, and next year I plan to attend Indiana University Bloomington, where I will double major in political science and criminal justice.
Good morning, judges. My name is Jazraj Denoya. I plan on attending Indiana University Bloomington and major in public management and leadership.
This year, our wonderful teacher coaches are Miss Janet Chandler and Miss Alana Kane.
Thank you so very much. We look forward to having a great conversation with you this morning. So I'll go ahead and read the question, and then we will hear your opening statement. We're doing question one. A result of the decision in Wisconsin versus Yoder is that any parent guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? How have courts balanced religious beliefs with other rights? We look forward to your opening statement.
Justice Sandra Day O'Connor stated,
Those who would renegotiate the boundaries between church and state must therefore answer a difficult question. Why would we trade a system that has served us so well for one that has served others so poorly?
Jake, Donia, and I disagree with the Wisconsin versus Yoder decision because it contradicts the principle of separation of church and state. Public schools are government facilities funded through taxes. However, churches are exempt from paying any income tax unless they owe income tax from an unrelated business.
The majority opinion by Chief Justice Warren Burger stated values and programs of secondary school were in sharp conflict with the fundamental mode of life mandated by the Amish religion. He also noted that the state's interest in universal compulsory education is by no means absolute to the exclusion or subordinate to all other interests. This decision favors more religious liberty.
I agree with the decision. In San Antonio Independent School District v. Rodriguez, the Supreme Court refused to examine the tax system funding education. This precedent, while 10 months after Wisconsin v. Yoder, affirmed the Constitution does not guarantee a fundamental right to education. However, the Free Exercise Clause of the First Amendment guarantees freedom of religion. This explicit free exercise clause and the lack of educational guarantees proves Wisconsin v. Yoder was a correct analysis, and that religious rights may supersede educational requirements.
In the Constitution, the 9th and 10th Amendments help provide for the right to an education. These two amendments work together to ensure that just because the right to an education is not listed in the Constitution, that a person cannot be denied this right as it falls to the state governments. 22 state governments directly list the right to education in their constitutions. However, all states offer a public education to their residents.
The Indiana State Constitution dictates in Article 8, Section 1, to provide by law for a general and uniform system of common schools, wherein tuition shall be without charge and equally open to all. This protects the right to an education by ensuring all public schools will be held to the same standards through uniformity, and that it shall be without charge.
The Virginia State Constitution protects the right to an education in Article 1, Section 15. The General Assembly shall provide for a system of free public elementary and secondary schools for all children of school age throughout the Commonwealth, and shall seek to ensure that an educational program of high quality is established and continually maintained. This protects an education by ensuring it will be high quality in its content and that all children of school age will be able to attend schooling.
Courts have balanced religious beliefs with other rights in many ways, both defending and superseding religious rights. Sherbert v. Verner ruled government cannot set certain employment eligibility requirements if it interferes with one's religious beliefs. The court balanced the right to religious freedom of the Seventh-day Adventists with the right of the government and businesses to set eligibility standards for employment.
However, the court superseded religious rights in Brown versus Roy of 1986, where it determined religion does not exempt someone from complying with federal regulations for Social Security, superseding the right to freedom of religion.
Former United States Representative Joseph Kennedy III stated,
"There is a difference between exercising religious beliefs and imposing them on others. Our Constitution fiercely protects the former and expressly prohibits the latter."
This is the conclusion of our prepared testimony, and we are now ready for your follow-up questions.
Thank you very much. So can the student's right to education trump the parents' right to exercise their religious beliefs?
I believe so, if this wasn't the case that the religious beliefs of the student interfered with the religious beliefs of the parents. However, in the case of Wisconsin versus Yoder, many of the justices noted how crucial it was to have the actual student testify and determine that it was the personal student's religious beliefs. I believe if the student didn't testify and it was clearly an issue of just the parents saying it's our religious beliefs, but you couldn't identify whether it was the students, then I think Wisconsin's Supreme Court's idea of forcing compulsory education further could have actually been upheld in the Supreme Court. I think that if both are shared, though, it is crucial, and that is where the decision came in.
Okay, that sounds like it's a fight between the religious belief of the students versus the parents. What about just the student's desire to have an education?
The student's desire to have an education, I believe, would over-trump the parents' desire to keep them out of it, unless the parents were to place them in a religiously affiliated private school, for example, that is deemed to be an equivalent substitution to public school. The state has an invested state interest in maintaining an educated populace, and so having a person or a group of people in a religion with absolutely no education is a detriment to the democratic process and the interest of an educated populace. So I believe that the court would rule that it is in the state's interest to force a compulsory education.
Notwithstanding the fact that there is no, written right to education in the U.S. Constitution, I thought I heard you in your prepared remarks say that Wisconsin v. Yoder was correct because religious rights are enumerated and education rights are not. How do you square that with what was just said?
While education is not explicitly listed in the U.S. Constitution, we still do have the Department of Education and legislative rights enlisted. And you can actually see a wave of incorporating education rights in the U.S. Constitution. Roughly 3 years ago, the Federal Court of Appeals actually ruled in favor of education under the 14th Amendment, when a group of students in Michigan sued as they were not taught the right to read and sued under the Equal Protection Clause. And the Federal Court of Appeals said that not being taught how to read amply actually violated that Equal Protection Clause of the 14th Amendment.
Additionally, under the 9th and 10th Amendment, any rights that aren't already listed in the Bill of Rights or in the Constitution are therefore in the power of the states. And I think that because it's not listed necessarily in the Bill of Rights, the power of education falls to the states, and it's under the state's jurisdiction to decide that.
Okay. Now, certainly, if a state offers a right to an education, it has to be provided equally, but does the state have to offer one at all?
I would argue that yes, the state does have to offer an education to its residents. We can see through the case of Plyler versus Doe, in which it was mandated that undocumented immigrants still have a right to educational access in the state of Texas. And this was a Supreme Court decision, so it applies nationwide. It almost established education as a sort of judicial right through that case, because it mandated that you can't deny someone an education simply because they're an undocumented immigrant because of the 14th Amendment's Equal Protection Clause.
You
I respect-
mentioned the Supreme Court protecting free exercise of religion in a very expansive way in Wisconsin v. Yoder and Sherbert v. Verner. The Supreme Court today, does it still protect free exercise rights amply, in your opinion?
Personally, I believe that the Supreme Court does protect free exercise rights. Specifically, you can look to the case of Masterpiece Cake Shop. That was decided in 2018, where the court decided that a shop owner's right to freely exercise their religion, in that sense, trump one's right to marry whoever they want. And so in that case, I think you can see that the Supreme Court does often still look to free exercise.
Following the reason from my colleague, I do think that the Supreme Court today would value more for freedom of religion. And we can look into the case of Espinoza versus Montana Department of Revenue, in which mothers wanted to apply scholarships for their sons, even though they attended a religious private school. And the state cannot do that because it was against their Rule 1 law that they cannot give tuition to private schools. And in the court, it ruled that it was actually against the free exercise clause. And the dissent stated that it was not, because it was not against the parents' job to right to petition. So I do think that right now, when it comes to the Supreme Court makeup of today, they would favor more for freedom of religion as opposed to like many of the other rights.
Additionally, more recently within the pandemic, there are two cases that come to mind. I believe just a couple weeks ago, Tandem v. Newsome was decided, in which it was determined that you still have a right to be able to gather in small groups. And additionally, there was also the case of Roman Catholic Diocese versus Cuomo coming out of New York, which stated that you cannot limit the occupancy of a religious service in the state of New York, as Governor Cuomo was trying to do to help stop the spread of COVID-19. The Supreme Court still found that the religious rights must be protected in that case.
Yeah, let me pick up right there. Some of the criticisms of those two decisions and in others in this pandemic era have been that they are too protective of religion. In other words, that they essentially favor religion over all other rights and interests. Is there a point where protecting free exercise violates the Establishment Clause? And where would that point be, if so?
One of the points that people who disagree with the Wisconsin v. Yoder decision, specifically the Wisconsin State Supreme Court, they brought up the fact that it is the state's interest to maintain a highly educated populace, and that is one of the reasons why they found in favor of the state of Wisconsin. I believe that this is an example in which the state felt that providing this free exercise of letting them leave school a year or two early than they would have been able to otherwise was an overextension of the free exercise clause, and therefore would have gone past this hypothetical line you speak of.
Also look at the Tandem versus Newsome case, which was decided on April 9th, for an idea of this. The dissent said that it was a blanket restriction on all occupancy in all people, so that it actually wouldn't favor the free exercise clause. And I think the line is, when does the free exercise violate the community's health or threaten the community's health? And that is where the concern came out of the Newsome cases or the Roman Diocese case in New York. And I think it is a very thin line and a very tiny gray area where you have that interpretation. How much does increasing a 3-household restriction of religious services go past the community health? And does that favoring of free exercise religion show that the government is favoring religion over free exercise of business and violate the Establishment Clause?
At what point should the decision be made by the executive rather than the judiciary?
I think in times of probably war, or during the time, as we see right now, as a national pandemic, it can fall to the executive to make that kind of decision.
Additionally, a method the executive can take is the executive order method, and that has been used extensively through President Trump's administration and President Biden's administration. And this may seem weaker than a lot of judicial activism or judicial cases. However, you can look at Regents of California versus Department of Justice, and that ruled when President Trump's administration tried to rescind DACA and remove that right. The Supreme Court said you cannot remove an executive order if you cannot provide a same right of substantial substance. And so that means that executive orders can actually be a substantial way of providing health benefits during this COVID-19 pandemic or providing rights in general.
How does the court protect free exercise rights in the public schools?
Free exercise rights are protected in public schools in multiple different ways. We can see that the court is unable to limit your practice of religion. So many cases, many schools have allowed, for example, Muslims to pray during the month of Ramadan, and they've accommodated different meals. So for our own school, they have accommodated ways to help those students be able to practice Ramadan.
And another court case would be Tinker versus Des Moines, in which children were protesting against the Vietnam War, and in which they had armbands wrist around their arms, and it was the side against it saying that it was a distraction from the school. However, it was ruled that students do have the rights to perform or to exercise their right to freedom of speech and right to protest, as long as it doesn't cause a disruption in the school. So for the courts, they would have to protect freedom of speech for children and the freedom of religion for children in schools.
Should those rights be protected in the same way?
Rights in schools are different than outside of schools. Your rights, I see my time has expired. Am I allowed to elaborate a little, or?
Just finish your thought.
Rights are different in schools. They are allowed to be limited in different ways than outside in the public, but you don't lose all your rights once you enter the schoolhouse gate.
All right, thank you very much. Thank you very much.
Yeah, let's recognize the students for their hard work and participation today. Congratulations.
All right, judges, thoughts?
Sure, I'll start. So first of all, deep breath, first one of the day done. Congratulations, although I know it's also kind of sad because it's your last week of people hearing of your wonderful careers. So I thought you guys did a very nice job. I thought on the prepared remarks, you covered the question, you covered the ground. I was a little confused where you come out on Wisconsin v. Yoder, and maybe it was just because there was disagreement within the panel. You started with saying, that you disagreed because it violated separation of church and state, and I didn't completely follow that thought. And then you came in and said it was correct because religion rights are enumerated and can trump the unenumerated educational rights. So that's a minor quibble. I thought on how have courts balanced, you might have had a few more cases in there and some more recent ones, like the Oregon v. Smith line of cases and the Church of Leukemia Babalu. But again, a minor quibble. On the Q&A, you had, good supporting evidence, and you were able, number one, you were very responsive and you all worked well as a team, and you were, had good supporting evidence and were able to reason to your answers. The Tandem case is a case that my office is handling and is near and dear to my heart, or maybe more accurately, the subject of my nightmares. So I would have loved to talk about that and what the Roberts Court is doing with free exercise clause all day. So I appreciated you mentioning that, and it shows that you're keeping up with the latest. So congratulations.
Thoughts, David?
I thought you did a great job. I echo the comments of my colleague. In your opening statement, I was particularly impressed with the opening quotation from Justice Sandra Day O'Connor. That's one of the things she was known for, was her sort of balanced treatment in the area of religious liberty. I also appreciated your citation to state constitutions. A lot of times we sort of have a myopic focus on the federal constitution, and a lot of times under our state constitution, we may have greater rights. I also appreciated your knowledge and application of the recent sort of COVID-19 religious liberty things. I think just a minor quibble, to quote my fellow colleague, on protecting free exercise in schools. One thing you might also want to think about is the Equal Access Act, and the fact that the kids can participate in all sorts of clubs, including religious clubs. Schools are not allowed to discriminate on the basis of religious or philosophical viewpoint. I thought you did an outstanding job. I loved all the participation and supporting evidence you provided. Great work.
I would tend to agree with my colleagues. Good opening, good structure. In the Q&A, I think we had a pretty good time. There were just sort of a couple pieces you do want to make careful when you're talking about cases to sort of be precise in terms of what you want. Certainly, Cake Shop was really not about whether there's a right to same-sex marriage. That was sort of to the side, but you are right that it's about free exercise in terms of, in part, free exercise, in part, freedom of speech, in terms of being able to decline to make cakes for same-sex weddings. I thought you guys used some pretty interesting examples, some pretty recent examples, and that's always a positive. Last piece is I thought it was a really nice job that you noted that an uneducated citizenry is a real problem. And that, of course, is a big piece regarding we the people. The whole point is to have an educated citizenry. Kind of an interesting question as to what you do when you do have an uneducated citizenry, but a citizenry that's still allowed to vote and make decisions. So I think y'all did a wonderful job. Good to see you. Good luck for the rest of the day, for the remainder of your units, and have fun.
Thank you all very much.
Thank
So
you.
much.
Congratulations again. I will now stop the recording.